So you got arrested, and now your family's waiting to hear your fate. What's the bail going to be? My name's Ryan with the R&R Law Group. Today we're going to give a brief discussion about the different types of bails or bonds in Arizona. So in Arizona Criminal Rules of Procedure 7.2 says that you are bailable as a matter of right. Now there are certain crimes that if alleged against you makes you non-bondable, which means that you cannot get out of custody. Some of the most common is if you are alleged to have committed a felony while on felony release. That can be considered non-bondable. Sexual assault, along with some other crimes, those are considered non-bondable. But for any other crime in Arizona, if the allegation is you committed a crime, you are bailable as a matter of right. Now, what does that mean? That means that a judge gets to decide what that bail is going to be. The rule says that it's supposed to be the least onerous condition in order to secure your appearance. It's also supposed to be to ensure the safety of the public, the safety of a victim. You know, there are other factors that go into play, but those are the main reasons that a judge looks at in order to determine what your bail is going to be. So what are the different types of bails? The first one, your own recognizance. That's the most lenient. That means that the judge is saying, hey, I'm going to let you out of custody today. You have court on, day 10. You need to make sure that you promise to appear. Do you promise to appear? Yes, I promise to appear. Okay, great. Then I'm going to let you out of custody on your own recognizance. You don't have to post a bond. You don't have to do anything else. You're going to sign for some paperwork. You have to show up for court when the judge says that you have to show up for court. That's the easiest bond condition that you could ever have. What's the second one? Pretrial services or some sort of supervision. What that is that that means that they're releasing you to an agency that's going to supervise you and make sure that you show up at court. So they may have drug and alcohol testing alongside of the release. They may have other conditions that you have to abide by. Generally speaking, you have to report to the pretrial service agency within 72 hours of being released from custody. But again, you don't have to have any money to put up in order to get released. You just have to promise to go show up at pretrial services, and then they're going to make sure that you show up at your court date. The next least onerous condition is a secured appearance bond. What does that mean? That means that you can post bond with a bail as bondman. Generally speaking, that means that if your bond was secured at $10,000, that means you would put up 10%. Now, each bail bondsman has their own fines, fees, other things that you have to pay in order to use their services. But generally speaking, it's 10% is what you put up, and then you have to have collateral for the rest of it. So a vehicle, a house, jewelry, electronics, those types of things you put up as collateral to cover that difference between the 10%. And then the bail bondsman is going to go down to the jail. They're going to get your loved one out and post the bail for you, and then you're going to report back to that bail bondsman, and the bail bondsman is the one that's promising the court that you're going to appear. Okay. The next type of bond that there is it's a cash-only bond. This means that the judge is saying, I'm going to let you out on a $10,000 bond, but you've got to pay the full $10,000 before I can let you out. There's no reason to use a bail bondsman in that instance because you're going to have to pay every single penny of it. It's not a 10% issue. You have to pay the full 100% for the cash-only bond. Okay. The last one that I have on here, it's an unsecured bond. It's somewhat newer in Arizona. I've only seen it done once, personally for some of our cases. But basically what that is that's a way for a person to get out of custody without posting any money. The judge is basically saying, I'm going to release you on the condition that you have a $10,000 or a however much dollar unsecured bond. And if you violate any of your release conditions, then that bond's going to become due. So let's say, for instance, you had that $10,000 bond and you didn't show up for court. Now you're going to get an arrest warrant, and then when they pick you up, you're going to have a $10,000 bond that's going to become due. Whether or not you finish out the case or you don't, you're going to have to pay that money back. That's the way that it's been explained. That's the way that I understand it. It's a newer type of bond here in Arizona. It's not happening a lot, at least from my understanding. Again, I've only seen it happen once over the past year with all of our clients. So that's just a little bit newer. So what are conditions of release? Most of the time, one of the very first conditions, obey all laws. You're going to have to obey all laws and show up for court. Don't drive without a valid driver's license. Make sure that you don't return to the scene of the crime. Don't contact any victims. Don't contact any witnesses. Don't contact the arresting officer. These are all general release conditions that are in almost every single release conditions that we see. Those things are things that are modifiable depending upon what those release conditions are. But these are generally all set at that very first hearing which you get arrested. That's why it's very important to have an experienced attorney with you at that initial appearance, because they're going to be able to argue that you be able to receive the least onerous condition possible. And if you go in there and a judge is thinking that a secured appearance bond may be more appropriate for you, but an attorney is able to argue on your behalf and say, no, judge, a secured appearance bond is not necessary. Pretrial services would be perfectly acceptable in order to secure the appearance at the next court date. Then that can save your family some money, as well as it can make your release conditions easier from the get-go, which means that you don't have to then motion to modify your release conditions at a later date. So these are the different types of release conditions that happen. Families ask us, when do I get my bond back if they posted bond? Your bond gets returned to you once your case is closed, whether that's by a dismissal or whether there's a change of plea or there's a sentencing. That's when the case is closed. And then that's when your bond can get exonerated. And then that means that the monies that were posted goes back to the posting party, and you're able to be done with your case. All right. If you have any questions, or if one of your loved ones have been arrested, haven't had a bond set yet, give our office a call. Those bonds get set within the first 24 hours of arrest. And if you have any other questions, just give us a call at the office.